A car salesman walks back to Sergio Ramirez with the color drained from his face. He leans in, almost whispering, and tells Sergio that Nissan cannot sell him the car. Why? Because TransUnion just flagged him as a terrorist. Sergio is not a terrorist. He's a guy in Dublin, California, in February 2011, walking in with his wife and his father-in-law, planning to drive home in a new family car. The list his name pinged is the Treasury Department's Office of Foreign Assets Control watch list. It's reserved for international terrorists, drug traffickers, and national security threats. U.S. businesses are legally barred from doing business with anyone on it. What flagged him was a piece of TransUnion software called the OFAC Name Screen Alert. It matched his name to that watch list using exactly one input, first name and last name. It ignored his middle initial. It ignored his date of birth. It ignored his address, even though all of that was sitting right there in his credit file, perfectly legible. His wife had to buy the car in her name. He stood off to the side. And the strange part isn't that this happened to one man. The strange part is that a credit reporting company had that kind of power in the first place. Because the system that branded Sergio Ramirez a terrorist started, in 1989, as a math trick to help banks approve credit cards faster. It begins with two men, Bill Fair, an engineer, and Earl Isaac, a mathematician. They met at the Stanford Research Institute. In 1956, they each put up exactly $800 to start a company in San Rafael, California. Their pitch was radical. They believed creditworthiness, the gut feeling a banker had about whether you'd pay him back, could be reduced to an equation. Cold math, no bias, no handshake. In 1958, they sold their first commercial scoring system to the retail giant Montgomery Ward. For 30 years, the model stayed niche. Bureau-specific risk scores trickled out in 1982. Then, 1989 happened. FICO released the first general-purpose industry-standard credit score, 3 digits, a range from 300 to 850. One number designed to do one job, predict whether you'd default on a loan. 6 years later, in 1995, the federal mortgage giants Fannie Mae and Freddie Mac issued written directives. Every lender doing automated mortgage underwriting had to use FICO scores, no exceptions. In one stroke, FICO became the gatekeeper of American home ownership. Today, around 90% of top U.S. lenders use FICO to decide who gets credit, at what rate, and on what terms. The big three bureaus now maintain active files on more than 200 million Americans. That's nearly every adult in the country, scored, sorted, and silently ranked. But to understand how that score escaped lending and ended up in your apartment application, you have to understand the pipeline. It has 3 layers. Layer 1, the furnishers. Banks, credit card companies, auto lenders, utility companies, debt collectors. Every month, they package your payment history and upload it to the bureaus using a standardized format called Metro 2, created in 1997 by the Consumer Data Industry Association. Here's the catch. Furnishers aren't legally required to send your data. They do it voluntarily, under a reciprocal deal. If you want to buy credit reports from the bureaus, you have to feed your own customer data back into them. So if a bank types a paid debt as still active, that error gets hard-coded into Metro 2 and broadcast to all 3 bureaus at once. One mistake, 3 identical lies. Layer 2, the big 3. Equifax, Experian, TransUnion. Despite what most people assume, these are not government agencies. They are publicly traded, multi-billion-dollar corporations. Experian pulls in around $4.34 billion a year. Equifax, $3.1 billion. TransUnion, $1.7 billion. Their product is you. Their revenue splits 2 ways. The first is bulk data sales. JP Morgan Chase or American Express will buy a list of 25 to 30-year-olds in a specific zip code with FICO scores above 700, then mail them pre-approved offers. The bureaus charge pennies per name, but they sell millions of names. The second is hard pulls. Every time you apply for a mortgage, a car loan, or a credit card, the lender pays the bureau between $10 and $30 for a full report and score. They match incoming data to your file using your name, social security number, birth date, and address. But because speed beats accuracy, they constantly merge strangers' files together. The industry term is a mixed file. Layer 3, the scoring engine. And here's the twist most people miss. The bureaus don't actually own your score. FICO is a separate software company. FICO designs the algorithm. FICO 8, FICO 9, FICO 10. The bureaus license it. When a lender requests your score, the bureau runs your file through FICO's math and pays FICO a royalty for every score generated. The exact weights inside that algorithm are a trade secret. FICO only tells the public broad strokes. Payment history is 35%, amounts owed is 30%, and that's it. The rest is locked away. Now, the original guardrail was the Fair Credit Reporting Act, signed by President Nixon on October 26, 1970. It was supposed to regulate all this, but Section 604 of the FCRA contains a loophole big enough to drive a system through. Section 604 says a bureau can sell your file to anyone with a legitimate business need connected to a transaction you initiated. That phrase, legitimate business need, is the entire reason your credit score is no longer about credit. The first escape happened in the early 1990s. FICO introduced the Credit-Based Insurance Score, or CBIS. Insurers discovered that, statistically, people with lower credit scores filed more claims. By July 2007, the Federal Trade Commission confirmed in a landmark report to Congress that 95% of auto insurers were using credit-based scores to set premiums. About 85% of homeowner insurers do the same. That same FTC report flagged something else. These scores disproportionately raised premiums on low-income and minority drivers. The math was neutral. The outcome wasn't, which means a driver with a spotless record and a stack of medical debt can pay double what their neighbor pays. Same road, same car, different number. The second escape, housing. Landlords don't pull standard FICO scores. They buy specialized tenant screening scores, ranging from 1 to 1,000, from companies like TransUnion SmartMove or RealPage. These algorithms scrape your credit report, criminal databases, and eviction records from local housing courts. The problem? Housing courts don't use social security numbers, so the scrapers match on name alone. People get flagged as evicted because someone with their name lost a case 3 states away. They get blacklisted from renting and never know why. And here's the profit loop. You pay a non-refundable application fee of $30 to $100. The landlord pays the screening company $15 to $40 wholesale. The landlord pockets the rest. If the algorithm is wrong and you're rejected, you lose the fee. You apply somewhere else. You pay again. Each rejection feeds the next application fee. The bureaus quietly admitted how broken the public record matching was. In 2015, under pressure from 31 state attorneys general, they launched the National Consumer Assistance Plan and agreed to strip civil judgments and tax liens from credit reports entirely. The data was too riddled with identity mismatches to defend. The third escape, employment. Under FCRA Section 604B, employers can pull a modified consumer report on you for hiring, promotion, or retention decisions. The employer doesn't see the 3-digit score. They see an Employment Insight Report, active credit accounts, payment histories, bankruptcies, all the financial bruises of your adult life. The 1996 Consumer Credit Reporting Reform Act built in a safeguard. Before an employer can reject you over your report, they have to send a pre-adverse action notice, include a copy of the report, wait roughly 5 business days for you to dispute errors, then send a final adverse action notice. In practice, many employers skip the window. The candidate never sees the report, never disputes the error, and never hears back about the job. The position is simply gone. How big is that error problem? On February 11, 2013, the FTC published its congressionally mandated study. 1 in 5 American consumers had a verified error on at least one of their 3 major credit reports. 5% had errors severe enough to push them into a higher risk tier, meaning they paid more for loans, more for insurance, sometimes thousands of dollars more, because of a typo or a mismatched record. Howard Shalansky, who ran the FTC's Bureau of Economics, called the numbers eye-opening. He warned that consumers who don't check their reports are potentially putting their pocketbooks at risk. Congress tried to patch the disclosure side. On July 21, 2010, President Obama signed Dodd-Frank. Section 1100F amended the FCRA so that any adverse action based on a credit score had to disclose the exact score, the range, and up to 4 factors that hurt it. It was progress, but it didn't make the underlying data any more accurate. It just told you, in writing, which broken number had been used against you. Meanwhile, FICO has tightened its grip. For years, it charged the bureaus under $1 per score pull. Then, in 2023 and 2024, it pushed mortgage pricing past $3 per score, a 400% plus increase. Federal rules require lenders to pull a tri-merge, scores from all 3 bureaus on every mortgage. That toll booth gets paid 3 times per home loan, and then it gets passed straight to the home buyer. There's a final piece of the irony. In 2017, Equifax was breached. The personal data of 147 million Americans walked out the door. The Bureau's response? Sell you credit monitoring, between $15.95 and $29.99 a month, to protect you from identity theft caused by the data they couldn't keep safe. Which brings us back to Sergio Ramirez. In February 2012, he filed a class action against TransUnion in the Northern District of California, case number 3:12-CV-00632. He certified a class of 8,185 people. All of them had been falsely flagged by the same OFAC Name Screen Alert. A jury awarded the class $60 million. He'd won. Then on June 25, 2021, the case reached the Supreme Court. TransUnion LLC versus Ramirez, 594 U.S. 413. The vote was 5-4. Justice Brett Kavanaugh wrote the majority opinion. His doctrine was blunt. No concrete harm, no standing. Mere risk of future harm, he wrote, was not enough. Only 1,853 of the class members had their false terrorist reports actually sent to a third party. Those people could sue. The other 6,332, whose files still contained the false terrorist label, just sitting there in TransUnion's database, had no right to sue at all. Justice Clarence Thomas broke from the conservative majority and wrote the dissent. He warned that the ruling ignored the injury that occurs when a company systematically maintains inaccurate records that brand ordinary citizens as terrorists. Congress, he wrote, is far better suited than federal courts to define harm in the digital economy. In December 2024, the Consumer Financial Protection Bureau, under Director Rohit Chopra, proposed a rule. It would classify modern data brokers, including tenant screening and background check companies, as consumer reporting agencies under the FCRA. It would force them to meet accuracy and dispute standards. The Consumer Data Industry Association immediately launched lobbying and legal challenges. By 2025, under a new administration, the rule was in limbo. So step back. The story isn't really about a number. It's about what happens when a private algorithm becomes a public utility without anyone voting on it. For decades, if you owned a home, your mortgage payments built your credit. If you rented, your on-time rent payments simply vanished into your landlord's bank account. The score punished you for not already having wealth. It was a closed loop. You couldn't build the score you needed to buy a house because the housing payments you were already making didn't count. And alternative programs like FICO XD remain opt-in and fragmented. And the model is spreading. Fintech companies across Latin America, Southeast Asia, and Africa now skip credit histories entirely. They score you using your GPS location, your contacts, your social media, your browsing habits. The credit score has become something its founders never imagined. Not a record of debt, a digital passport, issued by a private company, reviewed by landlords, insurers, employers, and dealerships. And somewhere, a salesman is leaning in to whisper to a customer that the computer has decided. The customer never agreed to be judged by it. They were just trying to buy a car.